Good evening, this is John Milburn for Laws 12063. This is Advanced Statutory Interpretation and Drafting. We're into week 11, and this week and next week, it's unusual in that we're dealing with material that is not accessible. So I suspect that if you're watching this as a recorded video, you're really keen to understand and learn. So thank you very much for doing so. We have one participant online. Thank you, Nadine, for attending the live session. So tonight we're dealing with correspondence and affidavits. And I guess if there is a theme, it will be in relation to without prejudice, communications, and issues to do with ethics. So when we're dealing with correspondence, primarily, of course, we think about correspondence to an opponent as lawyers or to a client. But there are many other recipients, of course, of the correspondence. It might be a court. There are special rules that apply in that regard. And whenever you're considering correspondence, it's a matter of melding some material that relates to good grammar, absence of legalese, and ethical requirements. In other words, think very carefully about the purpose of the communication. What is it that we wish to communicate in the correspondence or in the affidavit? So primarily we're taking the instructions from a client and we're writing something that represents the views of the client to some degree. However, we're not a mere mouthpiece, which means that we need to consider the Australian Solicitors' Conduct Rules and the Barristers' Rules about ethical obligations as to what we include in communications such as correspondence and affidavit material. It's not open slather. So we have dual ethical responsibilities towards the client and the court. And I'm sure that you'll recall that our primary responsibility is to the administration of justice, therefore the court in that regard. So during this unit, we've talked about planning the material that you write, using English language in an expert way, structuring the material, and all of that has come together in the assessment work that you've produced. But it's also, of course, directly relevant to producing correspondence and affidavit material. So there is no prescribed reading this week. However, by way of reference material, I've referred you to an excellent article by Declan McGrath called Without Prejudice Privilege. It's from 2001. That's available on Moodle with permission from the author, and Family Court of Australia fact sheet. I want to say permission from the author through the approval through the Hein Online process through the University Library. So of course you need to understand the key terms that we're talking about. When we talk about an affidavit, we're talking about a sworn statement. It's like a statutory declaration, but the intention of the affidavit is that it is meant to be evidence in a trial, in a hearing. So it's court-based material where a statutory declaration is not necessarily, and usually isn't, something that is court-based in terms of its intent. So for want of a better term, when you think about drafting affidavit material, think about it as if it was in place of you extracting material from a client in a trial by way of evidence in chief. In other words, that which is said by the deponent in an affidavit is equivalent, if you like, to that which is said by a witness in the witness box. And if you think of it in those terms, it will mean that you need to comply with some basic rules in terms of its evidential value, its relevance, its admissibility, and probative effect. So all those rules that apply in relation to the evidence that might be received by a court or a tribunal in oral form will apply if it's in affidavit form. Some other terms that you'll come across: bona fide, which is Latin meaning in good faith; extra curial, meaning out of court; salutation, being the opening piece of a correspondence; signposting, the use of headings or subheadings, topic breaks that you incorporate into your writing. And importantly, and one of the things that we will talk about in some detail tonight, without prejudice. So without prejudice is the common term for negotiation privilege. In other words, that which is stated in the context of what we're talking about tonight in communications, in correspondence, by one party to another in a genuine, bona fide attempt to secure a settlement negotiation. And the idea of without prejudice communication is that it can't be used in court proceedings against the party that provided the material in the without prejudice communication. But there are some specific rules. Declan McGrath's article, Without Prejudice Privilege, goes into that in a lot more depth, and I commend that to you. All right, so we'll start by talking about some letters. Any questions, Nadine, as we go? So thank you for the question. I'll just check. Is it right that an affidavit may not be admissible unless the deponent is able to attend trial? That's a good point. Not necessarily. That is a general rule, though. If the deponent of the affidavit, which is being presented effectively as evidence in chief, is not available, then depending on the court or the tribunal, the court may disregard it completely, or more often than not, may take it into account, but give it little or no probative value. In other words, acknowledge that it exists, but in its untested form, say, well, I can't really have much regard to it at all, or I can only have little regard to the content. So that's a really good point. Thank you. Hope that answers your question. So we'll now deal with writing of letters. There's a real trap with the digital age that we didn't have when I first started. So when I first started, everything was in paper form. Occasionally we used telegrams. We didn't have, of course, the internet. We used to use couriers, but it was all based on letter forms. So you had time to think about it, which meant that you had time to reconsider what you had written. Now, of course, with emails, it's possible to send something immediately, possibly in the heat of the moment, and people do a couple of things with emails that they tend not to do with letters, formal letters, that is. Number one, send them out hurriedly without necessarily proofreading. Number two, sending something that might be potentially emotive or ill-advised with the benefit of hindsight. And number three, relaxing the use of the language to a point where it becomes unprofessional. We need to guard against all of those things when considering writing emails in particular. Now, when you're writing any communication, you need to think about the recipient. I know that's a pretty basic comment, but it's a vital starting point. Who in fact is the audience? And that's relevant for a couple of reasons. One is that it may determine the level of your writing. In other words, if you're writing to a court or to another lawyer, you might use relatively complex language. You might use legal jargons. But if you're writing to a client, you may want to explain what it is that you're discussing in lay terms. So who is the recipient, which ties in very carefully now to what is your objective. So in order to convey the message, you need to have a very clear idea of what it is that you wish to convey. What is it that you wish to achieve? Now, it may be that you're writing to your client to inform them of the current situation, provide options and provide advice, for example. Or it may be to the other side. And you need to make it clear in doing so what it is that your client wishes to achieve in that correspondence. Now, a word of warning. When it comes to communications to the other side, you may need to consider the question of undertakings. And if you're going to give undertakings, be very reluctant to make them personal undertakings. And by that I mean, it's possible for a solicitor, for example, to provide an undertaking on behalf of a client to do something, but improperly worded, that undertaking becomes the undertaking of the solicitor or the barrister. So I undertake to pay the stamp duty, or transfer duty as we call it, on this contract, meaning the client undertakes to pay. If you word it incorrectly and things go badly, then whether the client lets you down or not doesn't matter. You'll be the one responsible for fulfilling that undertaking or that task. So that's just a general matter to consider when you're writing any communication or correspondence. So you need to think about the tactics, and you need to consider what you disclose to the other side and what you keep back from the other side. In other words, some cliches, playing the cards close to the chest, discretion is the better part of valor, and all of those sorts of things come into it. Now, a key part of correspondence and communication with the other side, as it were, in a dispute situation is that relates to without prejudice communication, which is closely aligned, of course, to without prejudice privilege. And we've probably seen this, something that's headed without prejudice. So what does that mean? When can you use it, and when does it actually apply? Sometimes it's used even by lawyers improperly. But it's very common to use the words without prejudice. And we typically put that at the top on the header. It can be in the footer, but usually it's at the top of the document. Very clear and very plain. And in fact, it's quite common for two letters to be dispatched by the same lawyer on the same day in relation to the same matter to the same recipient. One, what we call an open letter, is that which is intended to be presented to court or available to be presented to court should the circumstances deem that appropriate. And the other, which goes with it, is without prejudice. And in the open letter, you don't refer to the without prejudice letter, but typically in the without prejudice letter, you refer to the open letter. Look, I refer to my open letter denying any liability. However, on a without prejudice basis, I do have instructions for my client to engage in discussions with you in a genuine attempt to resolve the dispute. So that's kind of the idea of the open or the without prejudice or both communication. But one trap is that there's no magic in, Nadine says, I've recently dealt with call-to-bank offers without prejudice saves to costs. Yes. So that's a variation on the standard without prejudice. And it's very important. Call-to-bank offer simply means that it's something that remains unavailable to be produced to a court because it's part of a settlement negotiation, with one exception. And that exception, which relates to the phrase save us to costs, means I'm reserving my privilege in relation to this communication unless I am successful and it can be established that you should have accepted what I'm now proposing, in which case I'm going to produce this letter in relation to any argument about costs to show that I've incurred a substantial amount of legal costs after you rejected this letter of offer that I made, and therefore I should be entitled not just to the standard costs that I'd usually be entitled to, but I should be entitled to indemnity costs, meaning all of the actual costs and not just those that are awarded through the court system. Nadine, I hope I've explained that well. I'm sure you knew that, but for others that might be recording this, watching this recorded session. Now, Declan McGrath talks about without prejudice privilege and says that there are some preconditions for establishing the privilege. In other words, there's no magic in simply putting the words on a letter and saying, well, that therefore makes it without prejudice. You see, the communication, which is said to be without prejudice, must be made in a bona fide, genuine attempt to settle a dispute between the parties, and with the intention that if the negotiations fail, it won't be disclosed without the consent of the parties. So there's a few key words there. The first is this: at the time the communication was made, the party that purports to claim the privilege on that communication must be able to establish that there was a dispute in existence between the parties in relation to a legal matter. That's the first thing. There has to be some dispute. Otherwise, you can't claim without prejudice privilege. You don't have to have legal proceedings commenced, but you do at least have to have them contemplated. And the second aspect of the privilege is that the communication relates to a dispute between the parties in circumstances where there is a genuine attempt to settle the dispute. In other words, if the without prejudice communication relates to a dispute, but there's no element of furthering a settlement, then it can't be without prejudice. It can't be a without prejudice privilege. So the courts aren't really concerned about what is the substance of the settlement proposal. They're not really concerned about the nature of the compromise that is being sought. But what the court does want to ensure is that there's some dispute, and this is a genuine attempt to settle that dispute, or at least go some way towards settling the dispute. Now, Declan McGrath says in his material the following: a fundamental question which has yet to be definitively resolved is the precise ambit of the privilege, and in particular, whether it applies only to admissions as to liability made in the course of settlement negotiations, or whether it applies more broadly to prevent evidence being given of anything said in the course of the settlement negotiations. Support for both approaches can be found in the cases, and the authorities on the issues are not easy to reconcile. So we encounter this a lot in mediation work. So I do quite a lot of ADR work, and I teach it at the university. What sometimes happens is that people will go into a mediation and disclose something, but then try to hide that from the court or the tribunal ultimately hearing the matter on the basis that it was part of an without prejudice communication. So I think it's important for an ADR practitioner from the outset to make it clear what is privileged as part of the mediation and what is not. In other words, not everything necessarily can be the subject of a privilege claim. Now, there are some other ways that material that might otherwise be privileged can be released. For example, if there's a waiver. So if the other party says, look, I don't mind, you can disclose that, then the other party has waived the privilege in enabling the maker of the statement to release that content. And there can be an implied waiver. So even if a document is in an open letter, then it may be that privilege is contained given the nature of the communication. I hope that makes some sense. Sometimes legal professional privilege is not waived when a document is sent to an expert to prepare a report. And sometimes there can be inadvertent disclosure. Now, an example of this is the Crown against Tompkins. It's a 1977 case. The citation, if you want to look at it, is 67 CR APPR 181, it's English. What happened was this. Tompkins attempted to pass a note where he admitted perjury to his counsel, to his barrister during a trial. And this is really odd. The note fell to the floor and the Crown counsel picked it up and then used it for cross-examination. Clearly the initial intent was not for that to be presented to the Crown, but the court held in that case, and I think fairly tough decision, that Tompkins had lost his privilege in the document. Now, when you're thinking about privilege, without prejudice or any form of privilege, you need to consider the Evidence Act, both at a Commonwealth level and the Queensland level. So for the Commonwealth Evidence Act, look at sections 118 to 125, and that deals with the issue of client legal privilege, and the provisions cover confidential communications. All right, well, thank you for your patience so far. We'll keep pushing on. So without prejudice privilege generally only applies in these circumstances, usually only to civil litigation. Some commentators say only civil litigation. I say usually civil litigation because with the advent of case conferencing, it's now possible for without prejudice communications to be had between prosecution and defence in criminal matters. Without prejudice privilege usually only covers admissions. It's not restricted to communications by lawyers. In other words, even the parties communicating to each other can still be the subject of without prejudice privilege. And the case on that is Rogers and Rogers. In that case, before litigation, a separating couple entered into a lot of correspondence, both directly and through their respective solicitors. During the communication, the husband disclosed a lot of material about his financial position to his wife. She used that. He objected, saying, no, that's privileged. Now, bear in mind, this is 1964. And at that time, the High Court held that the family court should not have used that material on the basis of an award in favour of the wife, even though the husband had not said without prejudice. It was clearly provided in an attempt to settle ahead of litigation. That wouldn't apply today, but the principle remains. Now, I mentioned that there are some exceptions to the privilege. Number one is waiver, we've talked about. There are some others. Number two, to prevent the court being misled. Number three, to enforce a concluded agreement. In other words, to ascertain what the true position was between the parties when they had their agreement as a result of without prejudice communications. And the fourth, and Nadine, you're right on top of this, is to do with call-to-bank offers in relation to the issue of costs. So they're the four exceptions, if you like, to the operation of privilege. Waiver, to prevent a court from being misled, to enforce a concluded agreement, and finally, on the issue of costs. But other than in relation to those exceptions, the general rule is that where we have settlement negotiations, it's not admissible. So at a Commonwealth level, have a look at the Evidence Act, section 131, that deals specifically with that point and says that evidence is not to be adduced of any communication between parties in a dispute in connection with an attempt to negotiate a settlement or a document prepared in connection with an attempt to negotiate a settlement of the dispute. Now, this does not apply if the party consents or it's to contradict evidence or to avoid misleading the court or relevant to costs or a deliberate abuse of power. So there are a whole lot of exceptions and we've touched on some of them. Now, that's all I intend to say, just at least at this stage, in relation to without prejudice. Any questions, comments? All good? All right. And just finally, when it comes to the issue of communications that are formal for lawyers, the tone of the communication is very important. And the general rule is the tone that you want is that which conveys strength with courtesy. So I hope that makes sense. There are ethical requirements on you to be courteous in communications generally, but particularly in relation to the court and probably more relevantly to the other side. People tend to be on their best behaviour, don't they, when they're communicating with the court, but not necessarily when they're communicating with the other side. So a trap for young lawyers is to avoid the temptation to be very aggressive to the point of being discourteous. Right, let's talk about affidavits. I mentioned that affidavits are essentially that which would be said by a witness if they were in a witness box giving their evidence under oath. So it's not, for example, in civil law, a statement of claim. It's not a submission. It's not an argument. It is an affidavit is evidence. So therefore, some basic rules apply. The first is that it must be admissible. So what's admissible? If we go back to our studies on evidence, we'll remember that it's the evidence of a witness is that which is known to the witness through their own senses and no more. No opinions, no guesses, no hearsay, things of that nature. Now, there's a huge exception to this, and that is in many jurisdictions, increasingly so, the usual strict rules around provision of evidence are being relaxed. So in the family court proceedings, in relation to, say, children, you can include a lot of material which would otherwise be objectionable on the basis of it being hearsay. Likewise, if you're presenting material in a tribunal hearing, you have that same leniency in terms of what's included. But nevertheless, that doesn't provide you with a green light to write poorly. So you need to consider what the affidavit is intending to do, what is the evidence that's relevant to the matter, and then you need to express it in a way that best matches the expectation of the recipient, which will essentially be the court. Now, in the study guide material in Moodle, we've provided you with some content about preparing affidavits from the Family Court of Australia. The same applies to the Federal Circuit Court or the Federal Court, or indeed you can apply the material with equal force in the state jurisdiction. So I won't go through that in full, but I'd just highlight to you the importance of reading that essentially almost as a practice direction, saying, look, when you're preparing an affidavit, you need to include certain things, you need to exclude certain things, and you need to go about filing it and serving it in an appropriate manner. So the material talks about how to structure the affidavit, what to say in the affidavit, whether you can give your evidence in court instead. That depends on the ruling of the court generally. What should not be included in the affidavit, for example, opinion evidence, hearsay evidence, evidence of attempts to negotiate a settlement, which are privileged, and anything that you have advised to your lawyer or the advice that you've received by your lawyer, unless you wish to waive that. Then it goes on in the material to talk about how to attach documents and how to sign the affidavit material. All right, so from a practical perspective, that's important. Again, not that this week's material is examinable, but if it was examinable, I'd always encourage you to think about a few things that people don't quite often think about, and that is ethical obligations and things like practice directions, regulations and rules. Sometimes when answering questions, people don't think about those aspects. So an affidavit then is the sworn testimony of the person signing it. So therefore, if you're the drafter of that material, you need to be extremely careful. You need to ensure that the person who's signing it is not exposed to potential punishment for swearing an affidavit that's untrue. And as a lawyer, the last thing that you want is a suggestion made to the Legal Services Commissioner that the client didn't read the affidavit didn't know what was in it. That's why the incorrect information got through, because the lawyer said something like, look, it's all pro forma, just sign here. This is urgent, just sign it today. There's no time to read it, things of that nature. So not only do you have to be extremely careful in drafting the material, but you need to be careful in the way in which it's signed and then presented to the court, because it's a reflection on your client as the direct deponent, but it's also a reflection on you. Now, I mentioned that what goes in an affidavit needs to be evidentiary, if I can use that term. So, number one, it needs to be relevant. Remember from evidence, what's relevant? Well, evidence is relevant if it logically affects the probability that a fact in issue is true. That's the general principle. It has to be admissible. In other words, it can't be hearsay, opinion, or something that breaches privilege. It needs to be reliable, and it needs to have some degree of probative value. So they're general rules that apply for the provision of evidence, and in particular for affidavit material. There is a dynamic when it comes to drafting affidavits, and that is to downplay the truth to some degree. Now, I need to be careful about my wording here, but what I'm really saying is don't be tempted to ignore something that is otherwise true for the sake of a good argument. Try not to be tricky, as it were, in the way in which you draft the material. So it has to be truthful, is the key. There's no value, there's no ethical support for something that looks and sounds great if it's mostly fictional. But I'm sure we all know that. Where you sometimes find it difficult when drafting an affidavit is to avoid coaching the client. You might want the client to say something, but you've got to, it's a tricky balancing act. You can't afford to risk your reputation and your practicing certificate by including in an affidavit something which you have coached the client or the deponent to say. So just be careful about that. Now, when it comes to drawing affidavits, I've already mentioned something from the federal sphere. I'll mention something very important from the state sphere in Queensland. When drafting affidavits, have consideration to the Uniform Civil Procedure Rules. In particular, look at Part 7, which deals specifically with affidavits. That's Rules 430 to 441, 430 to 441 inclusive. So Rule 430 deals with the content of affidavit and says that the affidavit must be confined to the evidence the person making it could give if they gave their evidence orally. There are some exceptions. One is if the affidavit is being used for something other than final relief. In other words, if it's being used for an urgent application for an injunction, it might be an affidavit sworn by the solicitor based on information and belief of the solicitor as to the existence of a certain state of things. Just got off the phone, the client said, something urgent is happening, the bulldozers are here, we need to stop them. The solicitor says, we'll draft an affidavit and an application urgently. I'll prepare the material in the affidavit based on the information that you've given me and the belief that it's true. So if you're drafting an affidavit of that nature, the first thing you need to do is say, the material that's contained in this affidavit is based on information and belief. And here is the source of the information, and here is the belief, here is the reason why I believe it to be true. I hope that makes sense. Then there's some procedural matters. Rule 431 deals with the affidavit having to be in a prescribed or approved form. 432 deals with swearing or affirming affidavits, whether it's on the Bible or not. 433 talks about the certificate of reading or signature for the person making the affidavit. So I mentioned before, the last thing you want is the Legal Services Commissioner to receive a complaint that the person signing the affidavit didn't read it or didn't understand it. So if you have concerns in that regard, then you can provide a certificate which is about reading or the signature. And it's basically to say the affidavit was read to the person and the person seemed to understand. Now, in that regard, you're getting into capacity issues, which is dealt with in the Queensland Civil and Administrative Tribunal typically, and guardianship matters. In other words, you need to be satisfied that the person had capacity. So I'll leave you to read those rules at your leisure, but they are important. And in particular, when you're looking at, say, Rule 430, think about information to do with the statements made on the information and belief and the tests that go with it. Any questions? All good? All right. Okay, thank you, Nadine. I'm just going to digress now and talk about modern legal drafting in the context of correspondence and affidavits. I'm drawing this material that I'm about to go from this book, Modern Legal Drafting by Peter Butt. It's very good. Now, at 6.1, the author talks about how to draft modern documents and provides some commentary in relation to wordiness and redundancy. And I'll adopt these words, if I may, respectfully. Wordiness is the legal profession's most recognisable trait. Redundancy, its chief characteristics. Lawyers really do go on. Their motto might be, never use one word where you can use two, and the more you use, the better. And as an American judge put it, the legal mind finds magnetic attraction in redundancy and overkill. So those of you that have worked with me in the past will know that I'm very keen to advance arguments around the economic use of words and the absence of legalese. Now at 7.7, Peter Butt goes on to say, choose the simpler word or phrase where you can. He says, earlier we cited George Orwell's admonition never to use a long word where a short one will do. For many lawyers, this seems to be counterintuitive. They consider that their readers will somehow think less of them for using short, simple words. In fact, the opposite is probably true. Research shows that readers think more highly of writers who use short words than those who use long words. Even judges, as readers, have the same impression of lawyers who argue cases before them. Indeed, judges not only prefer plain language, but associate legalese with inefficient advocates and lawyers from non-prestigious firms. Now that's interesting. And then the author goes on to talk about the use of pretentious words and the alternative, which is preferred. And some of them might surprise you. For example, instead of using the word cease, use the word stop. And certainly, instead of cease and desist, use the word stop. Instead of chattels, why not use the word goods? Instead of the word evident, why not use the word clear? And then we've got the whole legalese bit. Hereunto for, use before. Herewith, use with this instead. So you get the idea. There's a whole range of them. And finally, from that author, at 7.23, Butt talks about legal jargon and says, allied to legalese is jargon, by which language is used in the profession. And he then goes on to illustrate in a parody. And way back in 1835, Arthur Symonds caricatured the jargon of conveyancing documents using as his example the gift of an orange. And he said, now what we could say is, I give you my orange. But what do lawyers do? They don't want to say, I give you my orange. They seem to say things like, I hereby give you my orange. Those extra words that are unnecessary. But then they go on and say, I hereby convey to you my orange and all my right, title, and interest in it. Well, what does that add? Then they go on and say, I hereby convey to you my orange and all my right, title, and interest in my said orange, together with the right to enjoy my said orange, as fully as I can enjoy the same. And it goes on from there. And that is exactly the sort of wording that I was reading when I first started studying law in the 70s and practicing law in the early 80s. Thankfully, things have changed dramatically. Nadine, you've been very patient. Just to wrap up for tonight, I mentioned that in the context of writing material, whether it's correspondence or it's affidavit material, you need to be mindful of ethical requirements. So, of course, use the Queensland Law Society Ethics Centre as wonderful reference material, and Stafford Shepherd and his team have done a great job in putting that material together. Think about the Australian Solicitors Conduct Rules and think about the Barristers Rules. And remember, of course, that one of the threshold learning outcomes for being a law student, that is outcome number 2, is ethics and professional responsibility. And that requires you as part of your studies when graduating to demonstrate an understanding of ethical decision making and an ability to respond to ethical problems, as well as developing ability to exercise professional judgment. So I'd urge you to look at the Ethics Centre, look at the Australian Solicitors Conduct Rules, look at the Barristers Rules, look at the Legal Profession Act 2007, and get a good idea of professional ethics. If you're looking at the Australian Solicitors Conduct Rules, the fundamental duties of a solicitor are contained in Rules 3, 4, 5, and 6. And Rule 3 is key. A solicitor's duty to the court in the administration of justice is paramount and prevails to the extent of any inconsistency with other duties. There are similar rules for barristers as well. All right, well, I'll wrap it up at that. Thank you very much for your patience. Before I stop recording, are there any questions? All good? All right, thank you. We'll see you next week for the final session, and all the best as you prepare for your final assessment, which is due next week. All the best then. Bye.